SJC-11569, Commonwealth versus Craig Mulgrave.
Mr. Scheimer, good morning.
Good morning, Your Honor. May it please the court. My name is Robert Sinsheimer, and I represent Craig Mulgrave.
Who's with you, Mr.
Oh, Ms. Parla-Greco, Lisa Parla-Greco. Thank you, Your Honor. This all too tragic circumstance comes before the court probably multiple times a year. We're not contesting, obviously, that Mr. Mulgrave was the physical instrumentality of his wife's death. I do want to mention one fact before I get into legal arguments, and I want to be very cautious because I promise I'm not seeking to excuse domestic violence in any way, shape, or form. But there is a sense in this record, if you read it, that Mr. Mulgrave was trapped in this relationship and that affected his mental health. And I may get into that in a little more detail. It's somewhat analogous. I want to be cautious, but I think it's a little bit analogous to those cases where we see a female who gets convicted of manslaughter because she's killed a spouse who was abusive. I'm not going so far as to call the victim abusive here. I was very cautious to say somewhat analogous. But there is this sense of, and the gender situation is unusual but not unheard of, where the male is really kind of trapped into a situation, and some of these analogies to abuse, he couldn't go anywhere on his own. He was constantly belittled. It wasn't physical abuse, let me be clear about that. But he was in a situation.
Like emotionally battered?
I appreciate Your Honor's question because my answer is obviously going to be yes, but I just want to be cautious. I don't want to make more of it than it is. There wasn't a heat of passion request. I just want to make sure that that aspect of the record is not overlooked because it's so clearly a domestic violence case, and I just don't want the fact of the homicide superimposing the empathy that might superimposing itself over the empathy that might arise to someone that may have been the victim of emotional battery, to use Your Honor's phrase. So that's the fact. Now these facts...
What good does that do you? I mean, let's assume that we
Big picture, which I'm going to get to right now.
Okay.
There are several legal questions that are significant from this horrible tragedy. And I'm going to go to the second one in the order of the brief first because, frankly, I think it raises a very big picture about our jurisprudence. But I'll be quick on it because I have a hunch, and you'll correct me if I'm wrong, that you may be more interested in the issue, the Commonwealth versus Berry issue that Your Honor wrote a concurrence on within the last year. But let me talk about this issue first of outright foreclosing the defendant from calling an expert witness. And frankly, one of the reasons I'm addressing it orally first is I'm not sure my brief itself really addresses the significance of this question, at least not in the way it hit me when I was preparing in the last couple of days. You know, this judge was awful cavalier in telling the defendant, you cannot have this expert, period. Not let's take it question by question. Not let's see how it goes, but you can't have them. And Mr.
There was a hearing on this, wasn't there?
There's a voir dire.
Where the judge gave the defense lawyer a chance to make the case for the witness. When I read the brief, I had the impression that the judge had just said, no, you can't do this, but it was...
No, I mentioned the voir dire. The brief clearly...
Yeah, you did. But the judge decided that after getting clarification on precisely what this witness was supposed to testify to, decided that the witness wasn't competent to testify to what had happened 15 hours earlier, right?
He might have said it that way, but that question, Your Honor, is exactly why I wanted to argue this first and why I really do think there's a bigger picture that may have been a little bit lost. We all know that as important as it is for a trial justice to do justice and to be an umpire and to decide profound issues, part of the job has also become case management. That's a reality that every one of Your Honors has faced. The problem with this particular narrow area of the law is that issue of case management has crept into the jurisprudence in a way that's unhealthy. And here's what I mean. The right to call a witness has to be the simple, most basic right.
Well, what was this witness going to say?
This witness was going to say that Celexa and alcohol is a bad mixture, and that Celexa and alcohol could cause someone to be irrational and even suicidal. Now let me go right to the core of Judge Hines' question. The fact that the evidence of suicide was 15 hours before the homicide, that's not irrelevant. That was what they tried to make it do. That's the government's position. The government's position is the guy was suicidal. He was crazy as a loon the night before. He was lying comatose on the ground. He had a noose around his head. Anyone would have pink papered him. But it didn't matter. That had nothing to do with the homicide 15 hours later.
But what would Dr. Stewart have added to that? That all came in, didn't it?
No, it didn't, most respectfully. And even they admit it in their brief, if you go back and look at it, very cautiously and extremely artfully written. Well, it wasn't quite the same, they say in their brief. It would have added a little because it would have talked about the mixture. And that's why I was talking about this bigger picture of case management. It wasn't just cumulative. And I think that that's where this problem crept in.
But what would he have said?
He would have said that Celexa and alcohol combined is a toxic mixture.
Well, how much Celexa and how much alcohol?
We don't know. And that was Mr.
We don't know, right?
We don't know.
Isn't that the core of the problem?
No.
Is that let's assuming that's true, it is relevant only if you can demonstrate that at the time of the killing he had used a mixture of Celexa and alcohol.
Respectfully, all these questions are drawing unfair inferences to the light most favorable to the defendant.
Well, show us, tell us what the affirmative evidence would be that he had used alcohol and Celexa on the day of the killing.
Because he's got a pill bottle next to him.
Had one missing, apparently.
He has one missing, which he probably had ingested. He's got a prescription for this stuff that he went and got. He's got a third of a bottle of rum missing, and he's comatose. This isn't like some guy that's walking
comatose at the time of the killing, or comatose? That's 15 hours before. We're talking about the time of the killing.
And I say, and this is exactly, the facts are undisputed. Doesn't defense counsel, hardworking, competent defense counsel, have a right at that point to draw on the juror's common sense and say, if you are crazy as a loon on the night before, you might still be a little crazy. You might not be able to appreciate the fact that you're hurting someone when you lose it the next day. And
isn't that what the other three witnesses testified
not
to?
exactly. Not exactly. And
but isn't that a problem of counsel's management of his witnesses? I mean, you get three witnesses, and none of them testified to the main fact.
Judge,
That's not the judge's problem.
No, but the judge made it his problem. That's why it's reversible error. Judge, You have a right, and this is why I go back, and I really do think this is a significant constitutional question. You're a trial lawyer. You have a right to call your witnesses. You don't even have to decide exactly what they're going to mean until you make your closing argument. You stay up all night. You do your closing argument after you've heard all the testimony. Mr. Hayden worked hard. He got that witness available. The taxpayer paid for that witness. The witness came all the way across the state to put on the record what he was going to say.
Well, maybe he should have to give his money back. What was the evidence that that this mixture of alcohol and Celexa that he had taken the day before had affected his mental capacity at the moment of the killing? Would Stewart have addressed that issue?
He couldn't have.
Well, then why was his evidence, his testimony relevant?
Because he could have addressed it as to the 15 hours before. Well, let me rephrase my earlier answer. The testimony of the state of mind of Mr. Mulgrave when he was photographed prone on the ground with a noose around his neck, that impacts.
Well, how tight was the noose?
I'm not sure.
Well,
it was taken off him the next day by the police when they arrested him. It was still on him. And I guess if you want me to be completely precise, I'm assuming the same inference I would have asked the jury to have if I were trying the case, that it was the same one. Maybe he took it off and put another one on. But because the problem for Mr. Hayden and the problem for the jurisprudence is that no one really knows what the guy did in those 15 hours. So you can't blame the trial lawyer for not being able to account for the unaccountable. What you should do instead, respectfully I suggest, is credit the trial lawyer for working with the facts that he did have. And I detect this notion.
But that's not what the trial's about.
Yes, it is. The trial is, respectfully, it's about putting all the pieces together in the ways that allow a trial lawyer to marshal his evidence. Everybody agrees that the state of mind of Mr. Mulgrave the night before has some bearing. No one disputes that. I don't hear anybody disputing that. It's just that everybody wants it the government's way, and I detect it. I'm trying to persuade you otherwise. There's a little bit of a bias from this honorable court, most respectfully. You know, what happened 15 hours before didn't matter that much. And what I'm here to argue on behalf of Mr. Mulgrave is it mattered a lot. The guy was nuts.
But stop. You need somebody to tell you why it mattered. In other words, that's fine for you to assert it matters, and it may as a matter of common sense, but it seems to me that since you're talking about drugs and alcohol, you need somebody to say it matters because these have an effect for X number of hours or whatever.
Well, that's a great point about this number of hours, and I'm not sure. I read the voir dire last night. I'm not sure that question was asked. I think, again, it is not, and I guess I better move on to the other issue. My argument, it's clear everybody understands the argument, so I'll move on, but let me just respond to your question and move on. The argument, and I don't think the court should be taking this cavalierly, respectfully, it's not the trial judge's place. Too much management has crept in. It was Mr. Hayden's right to put his witness on. Every single question, and I think I've gotten questions from all five of you, every single question you've asked could also at the trial have been asked of the witness on able cross-examination by brilliant prosecutors. Why does it have to foreclose the evidence that you have all these questions? That's for the government to fight about.
Well, there's some obligation on the judge's part to make sure that what the jury is about to hear has some relevance to the case.
It clearly had relevance, Your Honor.
Not if it doesn't have a basis.
It had a lot of relevance to Mr. Hayden because they wanted it out. Mr. Hayden wanted it in. Everybody understood it could be impactful. The judge took it upon himself to say, no, no, no. Not even, you can't even call him and introduce him. That is wrong. And it is a constitutional right to call witnesses. And it is the most basic right. Okay. And if nothing else,
I think we get that. So
yeah.
I think so. It may be best for you to move on.
I'm going to. But I ask you, even if we don't prevail on that point, to write something, I think that we have to be cautious about preventing the defense from actually calling a witness. This was done very cavalier. There was a voir dire, and I ask you to take a closer look at it, which is why I started with it. Now, the Rotowski issue, I call it for shorthand, the issue about the jury instruction is an issue that I think actually it came down before the filing of my brief, Barry, and I apologize. We didn't pick it up when we filed the first time, but it was within a week or a month or something. Obviously, this court is well aware that that's now a burning issue in the jurisprudence of homicide, that there's a real, there's a tension between Gould and Cunene that hasn't been fully resolved. Judge Gantz's approach was to consider, I guess, because that was a concurring opinion, it was a case that's positive, and you can correct me if I'm wrong, but to consider the notion that in the future, every case in which there's any kind of diminished capacity should simply be applied directly to the excessive, I call excessive force, excessive cruelty question. I think from the point of view of Mr. Mulgrave, the one and only client that I represent, my argument is the simple one, which is that Rutowski controls. It's the exact same case.
If Rutowski controls, the instruction was given.
No, it wasn't given the exact same
Not the
way.
instruction he asked for, but an instruction that is called for under even the new model homicide rules. So he as far as I can tell, he gave the instruction that under the new homicide instructions is viewed as appropriate. So you'd have to persuade us that that is indeed inappropriate and that an instruction based, I think, on the language of Gould should take its place and that it's reversible error for the judge to have given the instruction he did. Isn't that what your burden effectively is?
Yes, and the instruction itself is on page 165 of volume, I think it's 6 of the transcript. I have it right here. I can't, in the remaining 5 minutes, parse through clause by clause. What was not included was the phrase, whether the defendant intended to kill or cause grievous bodily harm to the deceased or was aware that his conduct betrayed a strong likelihood of death would result, as applies specifically to the question of excessive cruelty. In fact, the judge begins the paragraph with the phrase, more particularly. And that's exactly how it reads. I can open the page and pull it out. More particularly, with respect to deliberate indifference, you ought to pay attention to this, is how it reads. And it slides by what I call the Rutowski issue. So I don't think, frankly, that this is as clear as Rutowski. And I'm very intrigued, by the way. I didn't file a reply brief only because I think sometimes back and forth doesn't help this court. They ignore Rutowski. Their entire argument is if it didn't exist other than a CF, buried in a section of the brief that complies with the ethical rules. Very artfully done, but they don't meet the issue head on.
But in Rutowski, it wasn't given, and here the instruction was given. I haven't gone back to look to see whether he cited Rutowski, but the major difference is that in Rutowski, that instruction was not given, and here it was.
I guess we're debating the fine language of the instruction. I don't think it was given, but I can't possibly go back and say, okay, here's the 40-page instruction in Rutowski, here's the 40-page instruction in this case, here's the differential. I mean, I have my
Well, I mean,
my client's
you don't need to look very far. It's on page 28 of the red brief, which was cited by your brother. You may consider any credible evidence of the defense's mental impairment and/or the use of drugs in determining whether the defendant, and it goes on to speak of premeditation, and whether the defendant acted in a cruel or atrocious manner in causing the death of the deceased.
Yeah, it says it in passing. But that's not what the defense requested. The defense request was based on Rutowski, and that was not given. And the defense requested...
Well, I mean, I understand that, but that's why you need to say that this instruction, which is all that's called for in the model homicide instructions, is inappropriate, and that the instruction which comes from Gould, which of course we would have known about in drafting the model homicide instructions because it was long-standing, was required. I mean, that's basically your burden, which is a rather challenging one.
and I feel quite challenged, I might add. But we've briefed it. I feel comfortable with the brief. It's a struggle because you're comparing blocks of text, and I think and I guess maybe I'm saying this, Your Honor. It's also a struggle because I don't want to stand here and say I have a problem with the model homicide instructions.
Well, you can. I mean, Lord knows.
No, I understand that.
We have
But
said
I mean,
earlier that the model homicide instruction from '99 was an error, so it's not
understood.
as if we have not had
Understood,
trouble with
of course. What I mean is that the argument that it needs to be expanded upon is laid out in the brief. It was not complete in my judgment, and that's why I argued it. I think your own decision, Your Honor, in Berry suggests that this whole issue, and I may have shortchanged the issue a tad, because maybe the real issue is, shouldn't it simply be directly to the point that every single claim of impairment automatically raises the question of whether or not the government gets over the rail, the government can prove beyond a reasonable doubt the excessive cruelty, and that should be addressed clearly to the jury, and the jury should be instructed precisely on that. I guess to be succinct with the red light on, I do want to sum up. I do urge the court to rule that the requested instruction was the proper instruction. And if I've struggled in oral argument, I hope that can be as simply put as possible. There was a requested instruction. It's a good paragraph long. I would have lost the whole time if I read it to you, but that's what I'm requesting. Please find that was the appropriate instruction in light of Your Honor's decision in Berry. The third issue was interesting, but unless you have questions, I will see that my time is up, and thank you for your time.
Thank you.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. With the court's leave, I will track my brother's order and begin with the second issue of the brief. And it's important to lay out what the facts were here to counter the idea that the judge treated this in a cavalier manner. It was just the opposite. The defense faced the gap in the record, which was that the defendant said he had, and told his experts, and it was elicited at trial, that he had consumed medication and alcohol on the day before, roughly 15 hours before the stabbing, and in an effort to be knocked out prior to Christina Mulgrave's arrival back home. What he didn't say was how much he drank and what he took, particularly. And there were numerous bottles of different medication found in the house. The judge repeatedly inquired of defense counsel what was his evidence that there would be any effect of a particular medication on the defendant's conduct at the time of the murder versus the time of the February 8th alleged suicide attempt. And counsel said, and this was, we cite about 5 or 6 separate instances where counsel clarified that his purpose was not to show the defendant's mental state at the time of the murder. It was rather to show the legitimacy of the suicide attempt. And so, true to his stated intention at the voir dire, he elicited evidence that the defendant, or that Celexa and alcohol, when combined, can lead to suicidal or aggressive behavior. There was no testimony elicited at the voir dire at any point that that combination, alone or together, would have any effect on him 15 hours later. And it was further elicited on cross-examination that only one Celexa pill was missing.
Does this mean that the point of the defense counsel wanted the expert in order to be able to show that the suicide attempt was legitimate, and the fact that he had attempted to commit suicide itself was somehow indicative of his mental state 15 hours later?
That's correct, Your Honor. That's correct. So the legitimacy of the suicide attempt shows the extent of his depression, and his claim of diminished capacity was based on the alleged extent of his depression.
What's the problem with that?
Well, the problem with that is that the defense now claims in its brief that its reason for eliciting this evidence was to show an effect of the interaction of drugs or alcohol on his mind at the time of the crime, which is a very different claim. There was no evidence elicited on voir dire that it would have any effect 15 hours later.
Okay.
Was there any effort by the Commonwealth during the trial to suggest that his suicidal ideations, as they were testified to by the other two doctors, were in fact not real suicide attempts, or other than the testimony of Dr. Kelly? But was there an attempt to try to discredit those ideations?
Yes, Your Honor. In the cross-examination of both the experts, it was elicited that the defendant never said that he had attempted to, in fact, commit suicide. He had attempted to knock himself out prior to the arrival of his wife.
But he had actually made a statement, I think, to police to the effect that he had no suicidal thoughts. Isn't that right?
Correct. That's correct.
But the psychiatrist and the psychologist, I think, that testified, I think, said that they thought that he had suicidal thoughts.
Correct, and they stated that that was indicative of his lack of awareness of the extent of his depression. But Your Honor is correct that the Commonwealth, through cross-examination of both those experts, elicited the evidence that this was not, in fact, evidence suggesting this was not, in fact, a legitimate suicide attempt, but rather, in the words of Dr. Kelly, a gesture. That is a manipulative effort to manipulate someone else, but not a legitimate suicide.
So in those circumstances, why wouldn't it have been appropriate for counsel to offer testimony that it was a real suicide attempt?
Totally independent of how it connected to the next night, just to sort of it was a real suicide attempt.
Well, there were already two experts who testified that they believed on the night of February 8th that he had made a legitimate suicide attempt. In Dr. Davis's words, he was in the throes of a suicide attempt on February 8th. So that was cumulative, and the defense admitted that portion of Dr. Stewart's testimony was cumulative of evidence that was already in, that this was two experts had testified to that fact. Now, Justice Lowy appropriately brought up the fact that an expert witness generally may not testify to a person's intent. It was unclear whether it was a permissible area of expert testimony to say this is what the defendant intended at that moment. Of course, that's an inference that they could argue on the record, but they can't testify as an expert that he intended legitimately to commit suicide. That said, the defendant was permitted nonetheless to have two expert witnesses testify.
So was the ground that Judge Lowy kept out Dr. Stewart was totally because it was cumulative?
Three grounds, Your Honor. First, that it was cumulative, which the defendant admitted at trial. Second of all, that it was unclear, as I just said, that this was a permissible
But the other witnesses had testified to that.
True, that's true. But it's cumulative on something that it was unclear he was even entitled to anyway.
Yeah, but you even had, but didn't Dr. Kelly testify that, in his opinion, it was not a legitimate suicide attempt?
No, he testified in general about what a gesture involves. He did not testify that the defendant that this was not a legitimate suicide attempt. He testified that if someone was presented on February 8th at the emergency room, he would evaluate to determine whether he thought it was a suicide attempt or a mere gesture. He distinguished suicide attempts and gestures by basically saying the lethality.
So he didn't give an opinion as to whether the February 15th incident was a legitimate suicide attempt?
February 8th.
February 8th.
Yes. No, that's correct. Yes, he did not give any such opinion in that regard.
So cumulative it wasn't really something he maybe should be testifying about anyway. And what was the third?
And the third is, I would suggest, the most important, which is teased out in the justice's questioning my brother, which is that this only had, based on the voir dire testimony, a speculative connection to this case. That is, there was no evidence elicited on voir dire that any combination of alcohol or drugs would have any effect 15 hours later. So the testimony as listed on voir dire would be yet more testimony about his state of mind on February 8th. It would not have to do with his state of mind at the time of the crime, which is what the jury must
And
focus on.
that's what Dr. Davis and I forget the other doctor's name.
Dr. Joss.
Dr. Joss. That's what they testified to?
Correct.
Both the suicide attempt and his state of mind on the night of the murder?
Yes, correct. Correct, Your Honor. And yeah, neither testified that about any interaction of drugs or alcohol affecting him on the night. They testified that the legitimacy of his suicide attempt on the previous night, 15 hours before.
And his state of depression.
And his state of depression, that's correct. With respect to the first issue, which I will call the Gould issue, the Commonwealth, of course, agrees that evidence of mental impairment is to be considered on the issue of whether the defendant acted with extreme atrocity or cruelty. The model instructions in effect in 1999, which Judge Lowy applied in this case, and his actual instruction was consistent with those. This court has repeatedly said accurately conveys that concept as far as it goes, and the instructions contained at page 91 of the defendant's record appendix. To reverse on the ground, on that ground would be to reverse for doing precisely what this court has said to do with respect to what Gould holds. And I would also submit that the 2013 revision of the model instructions doesn't change that in any real way. With respect to the other issues, I would be happy to rest on my brief unless the court has any particular questions.
With regard to the text message, you agree that it's a somewhat different analysis when it is typed than when it is uttered?
Yes, Your Honor, and in DeMonte, this court said that the indicia of reliability when something is written must be greater than when it's spoken, but of course that was before the advent of texting and before texting became a ubiquitous means of instantaneous communication that many people use in lieu of speaking because it's quicker, or I could speak for myself in that regard. I'd like to make several points about the text message, if I could, with regard to whether it satisfies the hearsay exception for excited utterances. First, it was made within minutes of the alleged threat. It disclosed an ongoing threat. He is threatening to kill me. I am scared. He said if I pick up the phone, he will kill me. So using the present continuous text, it reflected an ongoing threat to her life. It addressed only the threat. Unlike the facsimile that was at issue in DeMonte, which was sent 8 to 11 hours after the alleged assault, and included information in addition to, the communicated threat in that case, or the communicated assault. There was also alternative plans for a concert that were included in that text, in that facsimile message. The text, I know this is characteristic of the form of communication, but it was one run-on sentence without punctuation or capitalization other than that automatically added by the phone. And the text itself indicated that the defendant had foreclosed Christina Mulgrave from calling. He said, if I pick up the phone, he will kill me. This court in DeMonte specifically noted, and citing another state's case, Bopri, that where there's evidence that essentially the victim was hostage and was foreclosed from oral communications by the defendant, then that's a circumstance where we would say it may be more permissible to allow a writing as an excited utterance. So I would submit that this is well within particularly based on the technology at issue, well within the hearsay exception, and of course not testimonial given this court's decisions in Lau and Linton.
Was there testimony as to whether the punctuation was typed by her or put in by the phone?
The prosecutor related that to the judge, and it was not contested by the defense.
I just didn't hear you said the prosecutor.
The prosecutor related that to the judge, and it was not contested by the defense.
That it was
then or now.
autocorrect. That it was autocorrect.
Correct, yes. With respect to the last issue, if there are no further questions with regard to the text message, with respect to the last issue, that is the judge's anticipatory ruling and whether it violates the Supreme Court's decision in James v. Illinois, I would just say that the defense cites no case, and we can locate none, that says the rule in James v. Illinois applies to the fact that a statement was made versus the substance of the statement. It's clear that witnesses other than the defendant himself may not be impeached with the defendant's statement that has been suppressed. But that's not what the judge's anticipatory ruling was in this case. The judge said, should you elicit from Officer Arriaga his silence, the defendant's silence in response to the initial booking questions, the Commonwealth will be permitted to rebut that with evidence that he had answered questions within an hour of that, the number of questions asked, and his demeanor while asking them, with none of the substance of the actual statement that had been suppressed. I would submit that that is well within his discretion to permit rebuttal testimony. And as this court has observed many times now, success in suppressing evidence isn't a license to invite inferences based on its absence. You can't exploit the suppression order in that way to essentially mislead the jury. So with that, I'd be happy to rest of my brief. Thank you.
Thank you. We'll take our morning break.
All right.